All right, good afternoon, everybody. As you're joining, we will get started in a minute or two. We'll let people join, but I think we will start. Let's give it one more minute for people to get in, and we'll get to it. Okay, I think our attendees have leveled off here, so we're gonna go ahead and get started right on time here. First of all, welcome everybody. See some familiar names in here, so thank you very much for attending today. We're going to start off our 2023 Club Development Webinar Series with obviously a very important topic as labor laws in California continue to evolve. Really important for us as youth sports and in general, and employers to stay on top of this to make sure we are not only in compliance with the law, but also serving our employees the best we can. So thank you guys for attending. A few logistics before we get going. Obviously, as an attendee, there's no video or audio. If you have a question, throw it in the Q&A section. I'm going to be monitoring the Q&As, and if it makes sense to jump in and ask the question of Brian as we go, I will. Otherwise, we'll have a time at the end to get to your questions. If for whatever reason your question does not get answered and you have something specific, I'm going to throw my email in the chat, and you can send me an email and I will follow up with Brian afterwards or with other NorCal resources to get your question answered for you. So with that, I'm going to introduce Brian Bertossa, and he's going to take us through California employment law as it relates to youth soccer clubs. Brian, it's all yours.
All right. Thank you, Dan, and hello to everyone out there. Pleasure to be with you today. We have till 1 o'clock. I'm going to try to make the most of our time. My connection to NorCal is through my childhood friend, Sean Blakeman. And thank you, Sean. And then thank you, Dan, for the opportunity. So I'm going to share my screen here. And hopefully everyone is seeing the welcome page, and we will jump right in. So really 3 topics I wanted to move through today as I understand the issues from Dan. One is the issue of whether coaches and other workers related to your clubs are properly characterized as independent contractors or employees, kind of the consequences of each classification. Second piece will be if your coach or worker is an employee, is that person exempt or non-exempt? And I'll explain what exempt and non-exempt mean and how those tests are applied. And then third, we're going to talk about wage and hour obligations that employers have to their employees. So that's the agenda for today. There's been a lot of change in California law, which I think is one reason why the independent contractor part of this is currently of particular importance. So we're going to start with that one. Independent contractor or employee. So California law puts the burden on employers to properly classify its workers, and merely having an agreement with someone that they are either an independent contractor or some other form of worker is not binding if the actual duties that are performed by that person don't meet the requirements. So unfortunately, we can't feel safe simply because we and I'll use the example of a coach, both want the relationship to be independent contractor and agree to do so. If what the coach actually does doesn't fit the definition of independent contractor, then they will become an employee, whether anyone wants them to or not. The downside of misclassifying someone as an independent contractor is a retroactive reclassification of the worker as an employee, And what comes with that frequently are penalties for things which we're going to talk about, like not paying overtime, no meal periods, no rest periods, because nobody thought those were required because we thought the person was an independent contractor. There's also a pretty steep penalty for willful misclassification. So California takes the view that if you know someone should not be an independent contractor, but you treat them as one, there's an additional penalty of between $5,000 and $15,000 for each violation of the classification rules. So there are downsides, of course, to misclassifying folks. So what's an independent contractor? What's an employee? Talk about that real quick. I think we all have kind of a common sense understanding of it, but an independent contractor is an individual or entity who contracts with another to perform work, but maintains control over the work performed. So the key word that comes up in all of these analyses is control. Who's exerting control over how the work is performed? Prior to 2018, that was really the only relevant analysis on whether someone was an independent contractor was how much control did the hiring entity exert? And there were ways to structure the relationship to minimize the control, to make the classification of someone as an independent contractor more defensible. As we're about to discuss, the ability to create the relationship has been severely limited by California law that went into place in 2018. So just to finish the slide here, some common characteristics of independent contractors: self-employed. They invoice for their work as opposed to being on the payroll. They receive a 1099, not a W-2. They set their own schedules, supply their own tools and equipment. Basically, they run their own operation. They're not subject to discipline by the hiring entity and retain control over how they perform their work. By contrast, I think we all have a good idea of what an employee is. That's someone who provides services for an employer. And again, coming back to the word control, in the context of an employee, the control is in the employer's possession. So work performance, schedules, manner and means of how the work is performed are subject to the direction of the employer. So I guess an easy contrast to start with would be if a club hires a coach and says, here are the 10 ways that you run a practice. This is the club method. That's a lot of control. If they say, hey, coach, great to have you aboard. Good luck with the team. We'll see you at the end of the year. That's very little control. So that would be less of an indicator of a employee relationship and more of an indicator of a collective or a independent contractor relationship. So as an aside, well, before we go to this slide, California is not an independent or not a neutral party in this. California wants folks to be employees more than they want them to be independent contractors for a variety of reasons. Payroll taxes are paid for employees that are not paid for independent contractors. Employees are subject to workers' compensation insurance. If they're injured, they qualify for unemployment. In other words, there's a bit more of a safety net for employees than there are for independent contractors. So, you know, to use a soccer term, there aren't a lot of 50-50 balls here. The scale has to be tilted heavily in favor of an independent contractor for California courts to agree with that the worker has been properly classified. So what changed in 2018? And by the way, we'll talk about what the law was prior to 2018 briefly in a minute. But the biggest and most important point is that the law changed in 2018 with something called Assembly Bill 5. So I will be referring to AB 5, which basically took a California Supreme Court case called Dynamics Operations and turned it into law. And it changed the test for who can be an independent contractor. And here are the 3 prongs of the test we have to meet now in order for someone to be an independent contractor. And you can think as we go along, Would the coaches in my club meet this? Would other people that we use meet this definition if we're calling them an independent contractor? So the first prong, we call it, the worker is free from the control and direction of the hiring entity with the performance of the work, both by agreement and in actual practice. So we talked about this a minute ago, and this is not new. It's this second prong that has turned out to be the killer. And that is the worker performs work that is outside the usual course of the hiring entity's business. So this is a new requirement as of 2018. So in the old days, if a plumber hired a plumber to perform plumbing, but did not exert control over how that worker performed the plumbing, the fact that the plumber hired a plumber to do plumbing was not disqualifying. It now would be for the most part. So if a plumber hires a plumber to perform plumbing, plumbing is the mission of the business and the service the business performs. And if the company has employees, those employees are performing plumbing work. So that is an automatic disqualifier under this new ABC test, is what we call it for these three prongs, A, B, and C. So this is what has turned the whole analysis upside down in the past 5 years. So for those of you that go way back with your club and have hired people forever as independent contractors and said, what's the big deal? We've been doing this since, the 80s. Well, the big deal is that the rules have changed. The third prong is the worker is customarily engaged in an independently established trade of the same nature as that involved in the work performed. So that usually means that the person we want to have be an independent contractor has a license, operates a business, sells their services to multiple businesses rather than a single one, and they are involved in the business that they are performing for the hiring entity. So these are the three prongs of the new test. So I like to put a lot of information in the slides. So if you end up forgetting everything I say, you'll still have a lot of information in the slides. So I'm not going to read every slide, but obviously there's a lot that goes into whether someone is free from control and direction. So the more that a worker is responsible for their own means and methods, the more it might fit the definition of an independent contractor. We talked about this. So even if you have an agreement which spells out all kinds of discretion for let's say the coach that you're hiring, but in practice, the club exerts a lot of control over that coach, over how they do things, the agreement itself is not going to hold up. And then prong B, this is the killer. To be an independent contractor, cannot perform the same types of services as the hiring entity. So I would encourage all of you to look on your website, see if you list your mission statement. What is it? Is it training kids? Is it improving skills of soccer players? All those things, and then match that to the skills of the person you are hiring. Are they performing services that fit that mission statement? If they do, this prong is going to be a big problem, a big hurdle. So these are examples of where this prong is satisfied. A retail store hires a plumber to fix a leak. So the retail store is not a plumbing operation. So when they hire a plumber, obviously the plumber is an independent contractor, not an employee. Here's some examples of where the person being hired does end up being an employee because they are performing work that is within the hiring entity's business. So again, I won't belabor the point, but that's a huge hurdle to overcome now that did not exist prior to 2018. Discussion of prong C. So when Assembly Bill 5 was passed, all the lobbying organizations went into high gear. So that everybody said, yeah, we think that new test is great, just not for our industry. Doesn't fit our industry, but it fits others. So everyone lobbied the legislature to try to escape from the new test. And many industries were successful. Unfortunately, youth sports was not one of them. but I do point out, Sean told me that, hey, Colorado passed an exemption. How'd they get that done? So Colorado had a similar ABC test, which went into effect, and their legislature passed a complete exemption for youth sports coaches. And I read the bill and it makes total sense. It's simply that California hasn't adopted it. So the Colorado bill says, part-time youth sports coaches for nonprofit clubs have traditionally worked as independent contractors. The relationship has worked. We think this relationship should be exempt from the ABC test. Boom, done. Hasn't happened in California. If any of you are connected to lobbying organizations that support youth sports, that should be something that is on the agenda for those groups to prevent this issue from becoming a bigger issue. So if you are exempt from AB 5, then you are governed by the old test, and the name of the old test is Borrello, which is the court case that decided that that test. And this is the one that goes back to simply how much control is exerted. And I will tell you that finding a worker to be an independent contractor prior to AB 5 was not easy. So it wasn't like it was a free-for-all prior to AB 5 and then it became difficult. It's always been difficult for some of the reasons I discussed earlier, which is the state of California prefers employees over independent contractors. So they criticize or they scrutinize independent contractor classifications quite carefully. And so even if youth sports had an exemption from AB 5, they would still have to meet this very lengthy test in order to classify workers as independent contractors. So here are the factors that applied back in the old days or still apply if you're exempt from AB 5. And you can see in this slide and the next, there's many factors. Whether the worker holds themselves out as being engaged in a business distinct from the hiring entity. So at its base, most of us consider independent contractors to be people that are self-employed running their own business. So that's what this factor is. Who provides the tools and the place for the worker doing the work? So if your club is providing coaches with all of the equipment, nets, goals, fields, balls, uniforms, all of that, that would tend to suggest less of an independent relationship with the worker and more of an employee relationship. The method of payment, again, does the worker invoice the club or is the worker on payroll? Does the worker have their own employees? Those are some of the control factors that are applied if you're outside of AB 5. So there are a few examples of exemptions which could conceivably apply to clubs and the club's relationships with some of their coaches. One exemption is called the business to business exemption. So as the slide says, this exemption is broadly used to cover contracted services rendered by one business to another, as opposed to businesses or services being rendered to the customers of the other business. So there's a 12, factor requirement that has to be met for that exemption to be in place. The second exemption, which could conceivably apply to soccer clubs, is an exemption that covers referral agencies and service providers. However, I'm not confident any of your clubs have set themselves up to be a referral agency, which is a necessary piece of the exemption, but it is conceivably possible. The third, just a kind of a side point, for whatever reason, competition referees are exempted from the ABC test. So I don't know why referees got special treatment in that regard, but they are specifically referenced as having been exempted. So here's a lengthy discussion of the business to business exemption. I'm moving quickly through this because I don't think a lot of this is going to apply, but it's all in the slides for your review. And as Dan may have mentioned, if you have any questions after the presentation about things that I may have glossed over quickly, just route your questions to Dan and he'll get them to me. So this is the referral agency exemption that I talked about. And of course, the whole key point is you have to be a referral agency, which is a business that provides clients with referrals for service providers to provide services under contract. Again, here we go with another 11-factor test that has to be met. And all of these are specific to this exemption and pretty difficult to meet, probably, for most clubs with their coaches, putting aside the fact that clubs are not set up, generally speaking, in my understanding, to be referral agencies. They're set up to be clubs that train kids and, you know, go to tournaments and the rest of it. So I wanted to kind of share a little bit of real life with you. I was, in preparing for this presentation, I found a lawsuit that's pending in Los Angeles against a large soccer club. And it was brought by current and former coaches alleging that they were improperly characterized as independent contractors, and they were in fact employees. So the first thing I would take out of this, I'm going to share some facts that they alleged, but the attorneys for the coaches spent a lot of time looking at the website of the clubs. So for any of you who will attempt or are claiming that certain workers, coaches, others perhaps are independent contractors, you should take a careful look at your website to make sure you're not contradicting that relationship through what you say on the website. So in this particular lawsuit, the coaches are claiming they were employees because they were hired by the club, and the club exerted an enormous amount of control. So what they alleged was the website represented that the coaches were employed by the club, which can be, you know, that can mean they are employees or they are simply utilized. But it says the club employs coaches to lead its competitive teams, to lead specialized training for goalkeepers, and performance trainers to work with our players as athletes. The website also described the coaches as being part of the club's professional coaching staff. So those facts were being held against the club. And again, I want to reiterate, this case is pending. So the club has not lost this case, but I'm just pointing out there is increasing litigation over this issue. The coaches' attorneys alleged in the lawsuit as a factor that leads to an employment relationship. The club did not require any of the coaches to have a license or registration of any kind, or to have any proof that they had an independent business that was being operated. They see that as a employment factor. All coaching work was done under the club's name. The coaches were required to wear club livery, they called it, meaning, I guess, uniforms and other apparel. All of these factors they're throwing in to say the club exerts too much control over these guys. They also, in the lawsuit, attacked any attempt by the club to claim any of the exemptions that I mentioned, the business-to-business exemption and the referral agency exemption. They specifically claimed that the club was not a referral agency, which took care of the biggest potential exemption, and didn't meet the business-to-business exemption. So that's just a real life kind of warning signal, I think, that, and I will tell you, plaintiffs' attorneys who I've been litigating against for 35 years, their herd mentality, if they see a successful case against one club, they're going to adopt that as a template and go after other clubs for the same types of claims. So that's just a cautionary tale there. So wrapping up the independent contractor versus employees, we start with a presumption in California that workers are employees unless you're, as the hiring entity, able to prove they're not. So how would you prove they're not? You would either satisfy the ABC test or prove that you're exempt from the ABC test and then satisfy the old test. So those are going to be pretty tight hurdles unless you're very determined to meet that test, and or you change probably some of the methods that you've used to supervise coaches and lessen the, or reduce the amount of control you exert over those folks. So that is the update on independent contractor versus employee. So let's move on to an assumption that the folks you're using are employees. The next step in the flow chart, so to speak, is, are employees exempt or non-exempt? So who cares? What's the difference? Well, the difference is that non-exempt employees are subject to laws in California that require the payment of overtime, the provision and receipt of meal period and rest periods, and exempt employees are not. So if an employee is exempt, they don't have to record their time. They don't have to be paid overtime. They don't have to worry about taking meal periods or recording them. Same with rest periods. So it's a much easier relationship from a bookkeeping and payroll standpoint. But this is another sort of trap, similar to misclassifying folks as independent contractors who don't meet the test. I can tell you, I have encountered many employers who have attempted to classify employees as exempt and found out through litigation that the classification was not appropriate because they didn't satisfy the two parts of the test for an employee to be exempt. So there's a salary test and a duties test. So we'll start with the salary requirement. So first of all, the employee has to be paid a salary. So it does not matter, and the salary has to meet or exceed this minimum amount of $64,480 a year. So if you are paying someone other than by a salary, it does not matter if that employee makes more than 64,000 or more than 100,000. You will not meet the salary test because you're not paying a salary. So you have to start with payment of a salary, which is a fixed recurring amount paid regardless of the number of hours worked. Then that salary has to meet this test, which is it has to be at least 2 times the state minimum wage. So the minimum wage is $15.50 now. Twice that is $31 an hour, 2,080 hours in a year. That's where you get the $64,480. So if you're considering classifying an employee as exempt, just start with the salary. And if it doesn't exceed that amount, you can just move on to having the employee be non-exempt because they won't qualify. If they do qualify, if they're paid a salary that exceeds this number, you're still in the game. They could conceivably be exempt if they also meet what's called the duties requirements. So to be exempt, you have to be primarily engaged in executive, administrative, or professional duties, which we'll talk about briefly here in a minute. And you have to regularly and customarily exercise discretion and independent judgment. So it's this second one that's frequently a problem. So employees who, let's use as an example, an employee who performs payroll, prepares payroll. That's probably not a task that requires discretion and independent judgment. It's more of a math and data entry position. So even if somebody conceivably was making a salary that qualified them to be exempt and holding that position, they wouldn't qualify because of the duties. So the employee must be primarily engaged. So they have to be performing more than 50% of their duties in the exempt duty category. So I won't spend a ton of time on these slides either, because I don't think this is going to be a big focus for most of you. But here are the types of duties that are performed by employees that are characterized as exempt. And you can see managing the company, directing the work of employees, hiring and firing, and using discretion and independent judgment. So those are pretty high standards to meet to be exempt. So before classifying someone as exempt, you should take a careful look, if you have it, at a job description to make sure it fits the exemption. And if it doesn't, and you want to, you can rework the job description so that the duties do meet the definition. But then again, they have to meet the definition in both agreement and in practice. So here are a few of those exemptions explained in more detail. Again, I'm not going to spend a ton of time on that. I'm sure I myself have been a volunteer in my kids' activities many times in my youth. I'm sure, or in my younger years, I'm sure many of you have volunteers that help with the clubs. California treats volunteers as not subject to wage and hour laws, provided that they are providing their services, their volunteer time to a nonprofit, and that the intent was that the worker was providing services with no expectation of being paid. So it's the second part that is probably one that needs to be confirmed before you assume that anyone is a volunteer for any extended period of time. I just threw this one in, even though volunteers don't have the protection of wage and hour laws because they're not paid wages, they are protected against workplace harassment and discrimination. Professional exemption. Now on to what I think is probably the part that would apply to all the clubs who have employees. And so I do want to spend some time on wage and hour obligations. So we've assumed in our presentation up to now, we've examined these employees and determined they're not independent contractors, they're employees. And then in our next step, we've determined that they are non-exempt rather than exempt. So now we're going to talk about the obligations employers have to their non-exempt employees. So just an introductory slide to say that California, I mean, I'm sure most of you have heard that California is currently going through a litigation boom over wage and hour issues, particularly in what's called a class action or a private attorney general act action. We call that PAGA for short. And by the way, the lawsuit that I talked about earlier that's pending in Los Angeles is that type of a lawsuit. So the attorneys are suing on behalf not simply of a single coach, but all coaches that worked for the club, going back probably 3 or 4 years, depending on the claims. So let's talk about how we can protect ourselves from claims like that. First of all, employees have to be paid for all hours worked. Of course, simple, easy, right? Well, when is somebody working and when are they not working? And I can see that being somewhat slippery for people like coaches of youth soccer clubs. So standing on the sidelines during a game, running a practice, that's pretty obvious. But what about at 10 o'clock at night, emailing out schedules, calling people to see if somebody is capable of playing or is going to be able to make a game? Is that work time? Well, here's the definition which helps us determine that. Hours worked include any time the employee is under the employer's control. There's that word again, control. So if the employer requires the employee to be somewhere and to stay somewhere, that time is compensable because they're under the employer's control. And also if the employer, and this is old language, so it sounds kind of funny, suffers or permits the employee to work. So if the employer knew or reasonably should have known an employee was performing work, that time must be paid. So let's say you have an employee whose schedule is 9 to 5, but every every night at 9 o'clock, you're receiving an email from them saying, hey, I just finished my paperwork and I'm submitting some various reports to you. Well, that sure looks like they were working at 9 o'clock at night. So the employer who says, well, I didn't know they were performing work because their schedule is 9 to 5. They're only supposed to work from 9 to 5. Well, in that circumstance, the employer would have known or reasonably should have known the employee was performing work in addition to what the employer had scheduled them for. And I will point out that if you do not want your employees to perform work outside of a set schedule, you are free to require them not to do so, and you're free to discipline them for doing so. So in our hypothetical situation, the employee has a 9 to 5 schedule and you're finding out that the employee is working every night from 8 to 10 on top of that. you can discipline them for that. You can order them to stop doing that, but you have to pay them for the time they worked, even though it was in contradiction to your direction, because it's work time. So the state looks at it as it was for the benefit of the employer and must be paid. But if it was not authorized by the employer, you can even all the way up to terminate the employee for working those hours. Rounding. I don't know if everybody's familiar with rounding, but let's say I clock in at 9:03 and I clock out at 4:57. Hey, we got a rounding policy. We round down to 9 and we round up to 5. Rounding has been around forever, but it is in disfavor now because courts are concluding that it isn't like the old days where most people wrote their time down on paper. There are very, very accurate timekeeping methods now. So the reason to round time has diminished because of advances in technology, and the state is suspicious that rounding works in favor of the employer far more than the employee. So I won't spend a lot of time talking about the details of rounding, but if any of you have employees and you use a rounding practice, I would suggest considering whether you have the ability to discontinue that. And there's a slide on this coming up, but you cannot in any event round time for a meal period. So here's some best practices, and the first one is the one I just discussed. Consider ending rounding. Another one is to stress to employees the importance of recording their time, because that's how you pay folks. So people who forget to clock in, clock out, or who present the same hours every day. They work 9 to 5 with lunch from 12 to 12:30 every day, even though you know that's not the case. You need to have a chat with those people, because it's conceivable they could in the future say that they worked far more time than they recorded and were, forced to record reduced hours or things like that. So you want to make sure that timekeeping conforms to reality. It's entirely appropriate for employers to require prior authorization before overtime is worked. So overtime in California is required for hours over 8 in one day or 40 in 1 week. So both of those are triggers for overtime. So from a financial standpoint, you obviously don't want your employees deciding to work a 15-hour day if it's not required and incur for the club an enormous amount of overtime. This last bullet point, verifying time entries. This is very, very useful to have employees at the end of each pay period, however your time is recorded, whether it's electronically, on paper, to have what I call an attestation saying, I certify that the hours above are accurate and that I took all of my required meal and rest periods. That's just good evidence if there's ever a dispute. Consider policies which state off-the-clock work is prohibited. There's always the well-intentioned employee or the sinister employee, right? Who says, well, I didn't want to charge you for my time, so I just wanted to catch up on some paperwork, so I stayed an hour late, but I'm not going to charge you for it. Well, you can't put the toothpaste back in the tube. Once you're aware, going back to our prior slide, once you know or should have known that somebody was working, you have to pay them for it. There's no such thing as off-the-clock work. Okay. Educating supervisors regarding the perils of communicating with employees by email, text, or cell during off hours. That goes back to what are compensable hours. And nothing creates evidence of hours that have not been paid better than email and text strings that show all kinds of communication outside of the normal work schedule. So meal and rest periods, this is something that trips up many employers, unfortunately, in California. So California requires that employees be provided a 30-minute duty-free, uninterrupted meal period and 10-minute rest periods subject to certain requirements. So a failure to provide that results in a penalty, which is 1 hour's additional pay for each meal or rest period that was not properly provided. So just as an aside here, it's not permitted for an employer to simply say, oh, well, forget meal and rest periods. I'll just pay the penalty so you don't get a meal or rest period. That's not permitted, but there is this penalty for inadvertent failures to provide or permit the employee to take meal or rest periods. So any employee who works more than 5 hours is entitled to a meal period. So some of these things, I'm not entirely sure how you employ people or what hours people work in your clubs. But if you didn't want to deal with a meal period issue and you have an employee who's working a 5 hour and 15-minute shift, you might consider changing that shift to 5 hours to eliminate the requirement for a meal period. Employees must also receive a second meal period for shifts over 10 hours. So unfortunately, this gets back to record keeping and timekeeping because California is extremely strict. So the first meal period must be taken before the end of the 5th hour of work. So if the employee starts at 8, the meal period must start by 12:59, which is 4 hours and 59 minutes. So I know this sounds incredibly minute and ridiculous, but it is late if it starts at 1:01. So if this employee, chose to clock in at 7:58, if they take that meal period at 12:59, it's late. So late meal periods have a cascading effect of penalties. It isn't just the 1 hour penalty. It can ultimately result in unpaid wage claims, which result in lots of penalties. So first thing is you want to make sure that all of your policies and written policies on meal and rest periods identify the proper time when the meal period must be taken. And then secondly, you need to make sure that it's being enforced. And then third, as I mentioned earlier, it's useful to have an attestation on your pay records where the employee agrees they took their meal periods. And then you also have the proper time in, time out for the meal period. If some of you don't have any electronic timekeeping and it's all honor system, you're at some risk. As I said, most employees, they're not going to sit there and note, oh, I went to lunch at 12:17 and came back at 12:48. They're going to write 12 to 12:30, right? But then they're going to say, potentially, if it ultimately becomes a dispute, well, I never really took 30 minutes. They just told me to write it down that way. So anytime you have time that's recorded the same every day, 12 to 12:30, 12 to 12:30, there's a suspicion that that's not accurate. So 30 meal periods have to be 30 minutes. Duty-free and uninterrupted is important. So, hey, yeah, the guy got 30 minutes to eat lunch, but he took 4 phone calls and had to talk to 3 parents about how their child was doing during the lunch period. Well, that's not really a duty-free, uninterrupted meal period then. So you need to make sure that the opportunity is there for a true duty-free, uninterrupted 30-minute meal period. Well, we talked about this before about meal periods having to be taken precisely on time, meaning not 1 minute late. And so the penalty is assessed when the meal period is missed, late, short, or interrupted. Hey, but a lot of employees, they're in the middle of things. They don't want to take lunch. Can't they just say, I'll take it later? Yes, under certain circumstances. So the first meal period can be waived if the shift is only 6 hours or less. So somebody's working a 6-hour shift. They don't want to take lunch. They're working 8 to 2. They're going to take lunch at 2 when they get off. They don't want to take lunch at 1:30 and end up with a longer period. Not 8:30, 12:30 would be. So it is waivable, but you're going to want to have a record that it occurred because that can be disputed later. Second meal periods, if you have coaches, for example, that are working very long days, they're entitled to a second meal period if they work more than 10 hours. So that second meal period can be waived, but only if the first meal period wasn't waived. So there's a catch there. A few tips on enforcing meal periods. if somebody is telling you they don't have a chance to take lunch, you're going to want to address that and not just let it become a problem. Perhaps there's ways to have some other employee give them a break, stagger breaks, et cetera, et cetera. This do not auto deduct goes with things I was talking about earlier. If the employer is tracking the employee's time and recording it, that's a bad start. You want the employee, him or herself, to be recording their time, which means that their time would be recorded accurately, not simply the employer at the end of the work week saying, oh yeah, I'm just going to deduct 30 minutes for your lunch every day, without knowing whether the employee took a lunch, when they took a lunch, whether the lunch was 30 minutes. So all of those things lend themselves towards problems. So the best practice is to have the employee, him or herself, do their own timekeeping and then verify the accuracy of that timekeeping, including the taking of meal and rest periods. And the attestation I use says, I took all my meal and rest periods as permitted, with the exception of : blank, and they can write in Monday, Tuesday, or if that's the case, and then they have to explain why they didn't take their meal period. If it was, I forgot, I didn't want to, then those are treated differently than I wasn't permitted to, or the supervisor told me not to take it. So one involves the penalty, and the other is an appropriate choice on the employee's part. They still have to be paid, of course, for the meal period if they worked through it, but there's no penalty attached to it. We talked about attestations for meal periods, process in place for reporting meal period violations, because you want to nip that in the bud. If there's an employee who's secretly claiming that it's not possible for them to take lunch, you want to smoke that out and address it so that the employee either stops not taking lunch or explains why they're missing lunch, and you can correct that reason for them missing lunch. Rest periods are somewhat similar to meal periods. Anytime an employee works at least 3.5 hours, they're entitled to a break, a rest period. And they're entitled to a rest period for every 4 hours or major fraction thereof. So an employee who works 6 hours is going to get two rest periods. Rest periods have to be at least 10 minutes. So again, similar to meal periods, if you're giving an employee a 10-minute rest period, but they're only getting 9 minutes because of being interrupted or things like that, then you haven't satisfied the obligation. Duty-free and interrupted. The example I used here was asking an employee to watch the phones while they're on a rest period. They're not duty-free if they're doing that. Unlike meal periods, rest periods don't have to be recorded because rest periods have to be paid. Your meal period is unpaid. Your rest period is already paid, so it does not have to be recorded on the timesheet. And it's actually a mess if you try to record rest periods, because how would you do that? Well, usually you would say, well, clock out and clock in. But again, the rest period is paid, so clocking out and clocking in can result in an underpayment of wages. Similar to meal periods, employers have to pay a premium when they violate a rest period requirement, and it's violated when the rest period is missed, late, short, or interrupted. This bullet point here, consider a 15-minute rest period. This is designed to take care of the issue of my rest periods were only 9 minutes, or once I went outside to have a rest period, I had to walk 100 yards in order to get off the field or something. So it wasn't a true 10-minute rest period. If you build in a little cushion with a 15-minute rest period, you're less likely to have those kind of problems. Attestations, we talked about this, reporting mechanisms. Expense reimbursements. So doubling back for a second, true independent contractors are not entitled to expense reimbursements. Expense reimbursements are required for employees. Independent contractors are considered to be running their own business and responsible for their own business expenses. But as you can see in the bullet point here, employers are required to reimburse employees for all reasonable and necessary business expenses incurred by the employee in carrying out his/her job duties. So the word reasonable and necessary, those are important words here. Carrying out their duties is also important. So a big one here is if employees are required to use their personal cell phones, whether to communicate with their employers or as a timekeeping application, the employer must provide a reasonable cell phone reimbursement. So in this day and age, it's pretty difficult to prevent employees from using their personal cell phones because most people prefer using their personal cell phone to some other employer provided device like a laptop or something else. Oh, it's just easier for me to use my cell phone, or oh, I was in the car, so I used my cell phone. If that is being used for the benefit of the employer, you have to identify a reasonable cell phone. So what's the reasonable cell phone reimbursement? Well, it doesn't necessarily have to be the entire cost of the employee's plan, but it has to be some estimate of the percentage of time the employee is using their personal cell phone for company business. So again, the word reasonable. If you have employees who absolutely use their personal cell phones constantly for business, the easy answer might be to provide them with a cell phone, buy it for them, have it be a company cell phone. Then you don't have to worry about the reimbursement issue. Court case held that even though an employee was on a plan with their spouse and their cell phone had no cost to them, the employer still had to reimburse the employee for a reasonable percentage of the plan's cost because the employer benefited from the employee's use of the cell phone. So cell phones are a big one. Employers must also reimburse for mileage if the employee is required to engage in business travel using the employee's personal vehicle. That should be pretty straightforward. Here are some examples of circumstances where employers do not have to reimburse for particular expenses. So expenses unrelated to job duties, such as using a company card to pay for entertainment while on a business trip. Unreasonably high expenses, so they're supposed to stay at the Motel 6 and they check in at the Ritz for $400 a night. That would be unreasonably high, and you can contest that expense and reimburse them for the reasonable expense, although you do run the risk of the employee making some argument that they had to stay where they stayed. There was no other place open, every place else had no vacancies. We got snowed in and had to stop somewhere we didn't expect, all those things. So you don't want to be overly rigid about that. But if the employee had opportunities to stay in a place that was reasonable and chose not to, you can contest that expense. And then, of course, expenses that, while business related, are unnecessary, such as buying new furniture without authorization. So I made it with 5 minutes to spare. Dan, are there any questions that I can fit in before we have to say goodbye?
Yeah, I think there's a couple good ones. So there's a question regarding overtime and the number of days. I know we touched on obviously the more than 8 hours per day, but can you just kind of describe the overtime hour or the overtime rules as it relates to the number of days in a week or the total number of hours in a week?
Yeah, so if someone works, well, I should say there is a limited ability in California to have alternative work week schedules. So schedules like 4 days, 10 hours. There are all kinds of rules that apply that have to be followed: secret ballot elections, distribution of all schedules, accommodation of people who can't use the schedule. So I don't want to portray that as readily available, but there is the ability to have schedules of more than 8 hours a day without incurring overtime. But the 40-hour a week is rigid. So if somebody works 8 hours a day, Monday through Friday, and then they work, 10 hours or 8 hours or 5 hours on Saturday, all of Saturday is in an overtime posture. So once you exceed 40 hours, there is, it's just a pretty straightforward calculation. As far as the number of days, there has to be a day's rest in 7. So you can't work people 7 days a week. If you do, there's additional requirements. I don't have them readily available. I can pull those for anyone who's interested.
Great. No, I think that answered it. There's also a question regarding volunteers who are performing duties that would otherwise be performed by an employee. So for example, if a volunteer board member steps in to be a coach for a team that was, let's say they were paid previously, employee left and a volunteer board member steps in, is there under law a expectation that that person is then compensated for that?
Well, the expectation that we care about is the expectation of the board member in that circumstance. If the board member says, okay, you don't have a coach, I'll step in, but I'm not doing this for free. You can't say, well, you're a board member and you have to perform volunteer work as part of your board duties. So yeah, we're going to use you as a coach and we're not going to pay you. If somebody says, I'm not a volunteer, you have to respect that statement. If somebody says, alternatively, hey, I can coach and I'll do it as a volunteer, then we have the intent we need to treat that volunteer as a true volunteer who's not subject to wage and hour law.
Got it. Okay. So there's a lot of questions around mileage. So I think I'll try to get this with maybe 2 questions for you. But the first is with regards to travel. So is travel to and from games treated in terms of payment? So for example, if a coach from the Bay Area is traveling to Fresno for a game, let's call that a 6-hour round trip, obviously they need to be reimbursed for their mileage to go there, but do they also need to be compensated for that time?
Well, so there's a lot of nuance to travel time. So as a starting point, commute time is not compensable travel time. So if your coach is driving 40 minutes from home to run a practice, that 40 minutes is not considered to be compensable time. If the employee is driving longer than a normal commute in order to perform work, then the time beyond the reasonable commute becomes compensable. And when does that occur? Well, there's no, oh, it's 75 miles or it's 2 hours. There is unfortunately no rigid rule on that. So I can tell you in the construction industry, there's some authority that a longer drive, a longer commute is appropriate because construction is transitory. Maybe soccer clubs are like that in the sense that you're going to Fresno, you're going to Reno, you're going to various places, as opposed to every game being played on the home field. That's a predictable distance. So the starting point is mileage is owed for the use of the employee's vehicle. That's just a given. And then the question is, when does it turn into compensable time? And I will also tell you that when it does turn into compensable time, it is permissible to have a different rate for travel time than for coaching. So you could say, $15.50 is the minimum wage. Once you get beyond your reasonable commute, you are on the clock and you are being paid at our travel rate. I'm using a lot of bunny ears here. You're being paid at your travel rate of $15.50 an hour. And we would ask you, coach, to record your travel time and to let us know when you stopped traveling and began coaching or performing some other activity. So then you've got compensable time, but you've got the employer having paid that time. I hope I touched on the question.
I think so. I think so. And again, for those who joined late, if there's questions that are not answered here, my email's in the chat. You can find it on the website as well. Feel free to email me and I can get answers back to you either from Brian or from other resources from NorCal. So just a few more here, Brian. I think I think I know the answer to this, but I want to put it to you just to make sure. There's a question regarding the difference between non-exempt salaried and non-exempt hourly employee. My understanding of that law, the way you explained it, was that a non-exempt employee is basically an hourly employee at all times. Is that a correct kind of way to put that?
Yes, you could have an employee who's paid a salary who is non-exempt because the salary isn't of the appropriate amount, and you could go into that with the understanding that the employee is salary non-exempt, but I would never recommend that because you're gaining no benefit from having the employee be salaried in that circumstance, because you would have to have the employee record all hours worked and then transform the salary into an hourly wage for purposes of calculating overtime, and you'd still have to comply with meal and rest periods. So if somebody is not going to be exempt, either because of duties or because their salary, let's say they're paid $50,000 a year in a salary, there's really no point in having them be salaried non-exempt. It just makes the record keeping more difficult in my experience.
Okay. Another, I think, pretty quick one. There's a question regarding mandatory training. So things like fingerprinting, background checks, those kind of things that are required for the employee to do. Is that compensable time that they must be compensated for?
Yeah, great question. Generally, yes, onboarding and required training and things of that nature are compensable work time.
Great. Then I think, well, maybe not a quick one, but I think a really important one from my perspective, knowing kind of how a lot of clubs operate. There's a question around if an employee can be an employee and a contractor within the organization for different roles. So, for example, they might be an employee as a coach, but they must also serve another function in the club. Let's call it maybe marketing, or I don't know, tournament operations or something like that. That may feel. Let's say, just assume for the second that does qualify as an independent contractor. Can one person be both?
Conceivably, but it's going to be difficult. The employee would have to meet the independent contractor requirements for, position A, and then you'd have to make sure that they are properly compensated when they're performing work as an employee. And you'd have to maintain the separateness of those positions and have the appropriate record keeping, and the employee would have to meet all the independent contractor requirements, invoice for their work as the independent contractor. So it would have to be a very carefully segregated set of two positions, as opposed to just sort of a blurred line of, hey, sometimes he or she's doing this, sometimes that. So what isn't good is trying to estimate how much time was spent on each, as opposed to having a precise record keeping of the hours worked as an employee. I would be very careful about trying to do that.
Okay. Two last quick ones, I think. There's a question around compensation for canceled events. So, for example, if we have practice, it rains, fields are closed, that is canceled. Is the club responsible for compensating the employee for that cancellation?
Well, so the answer to that is going to be, did the employee show up? So if there's going to be a Sunday game and Saturday night it's pouring rain and somebody notifies everyone the game is canceled, then the employee did not spend any time trying to complete that task, right? They didn't show up at the field on Sunday. If they show up at the field because they didn't get notice or it wasn't clear if it was going to be canceled, then a non-exempt employee is generally entitled to show up pay. So there is generally a requirement for that. I mean, things like act of God. So we all get there and think we're going to play, and I don't know, electricity goes out and we all have to go home. No advance warning. There's an exemption to the show up pay for things like that. But generally speaking, if the employee reasonably shows up prepared to work a scheduled shift, they have to be paid show up time, a non-exempt employee.
Okay. And then last one, there's a club that, a question around time tracking. So can an employer mandate that employees use a punch clock, or, log it on a mobile phone or whatever the kind of application is. Can that be mandated for their employees?
Yes. I mean, the alternative would be what? Just sort of random scratch paper or emails? Yeah, I mean,
No, I think the alternative is, or the other situation, and I personally have been in this situation running a club as well, and it can be difficult. So I understand where the question's coming from. That there's a lack of expectation, or we can't expect coaches to punch a clock because they're all at different fields and it might not be accurate and all of this. So what ends up happening in practice is a lot of coaches will fill it out like, at the end of the week or the end of the pay period. And obviously then you lead to not very accurate records as well as rounding or, whatever. And so the question is, hey, like, that's great, but can we mandate that they do it day of, at the time, et cetera?
yeah, yes, but again, we have to bear in mind that the employee cannot be forced to pay for any kind of apps or anything like that. It all has to be at the employer's expense, or they have to reimburse the employee for any requirements the employee has to meet. But yes, the employer can mandate how time is recorded. I will say this, if the employee fails to record their time properly, you can't ignore the fact that they performed work. You have to correct that and pay them for hours worked as best you can, and then tell them, can't do that again, got to use the app, all those types of things.
Okay. Well, that is all our questions. Brian, is there any parting words or advice you'd have to anyone who's here?
Not in particular, but I will readily admit that I'm sure there are a million nuances and nooks and crannies to how clubs operate that I didn't understand or glossed over in my presentation. And for that, I apologize, but I'm happy to try to answer questions again through Dan that might not have been covered in the detail you hoped for in the presentation. And I appreciate the opportunity. Thank you.
Well, Brian, thank you so much for being with us today. As I mentioned at the top, I think it's a really, really important topic and something that we, especially in the youth sports industry or youth soccer industry, for sure, don't get a lot of information on, and it's really dense and difficult to get through. So we really appreciate you being here. Again, if anyone has questions that were not answered to the level that you needed it or whatever it was, please email me. I'm going to throw it in the chat one more time for everyone to see. It's at the bottom here, I think, but I'll do it one more time. Send me an email and we will do our best to get you an answer. So thank you guys very much and have a wonderful day.
Thanks, everybody.